All right. Good morning, everyone. My name is Arlisha Wilson. I'll be the chair of today's meeting for today, Monday, October 20th. We'll get started first with the reading of the preamble. Madam Secretary.
Thank you. Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals. I'm going to read the preamble for you this morning, this Monday, October 20th, 2025. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that calling users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who provided written comment on a particular matter. Back to you, Madam Chair.
All right. Thank you, Madam Secretary. Can we call the roll, please?
Sure. Ms. Faith?
Here.
Ms. Holzer?
Present.
Mr. Madison?
Present.
Ms. Rota? Present. And Ms. Wilson?
Present.
Madam Chair, we have a quorum of 5 members.
Okay, very good. Do we have any postponements or withdrawals today?
We do. We have 2. The first one is calendar number 25-183 at 414 East 146th Street, Premium Properties, Ohio, LLC, proposed to change use of existing 2-family residence to a 3-family residence in a B1 2-family residential district. The appellant's attorney has a conflict and is requesting a continuance. He has to be in court in Akron. He
Okay.
did not specify any time. However, due to the number of cases, it'll be at least 30 days. And I think the last week of November, we only have 4 members, so we may want to put this one on the first week in December.
Okay, that sounds good. That would be December 1st. All right, so that is going to be postponed until December 1st. This is calendar number 25-183. So if you are present for this case, you are free to leave. We will not take testimony in this matter. Are there any other postponements or withdrawals, Madam Secretary?
Yes, I should announce this one. We did send out notices on this calendar number 25-152 at 4239 West 143rd Street, Samuel Rivera, proposing to construct 960 square foot, 1-story metal frame garage on a 4,200 square foot lot in an A1 single family residential district. If you may remember that this was postponed to allow time for the appellant to work with the City Planning Commission to adjust the location of the garage. It's taken a little bit longer than expected, so we needed to push this to November 3rd. In fact, we may need to push it to November 10th, which we can announce at the next hearing if we need to do that. It'll be within the next day or 2 that we would decide if that needs to happen.
Okay.
So at this time, it's on the November 3rd agenda, and we would not take testimony this morning on this.
All right, so just to reiterate, that's calendar number 25-152. If you're present for this matter, we will also not take testimony in this matter. Does that conclude our postponements and withdrawals?
Yes, it does. Thank you.
All right, so we're going to float back up to the top of the agenda. I have calendar number 25-173. Is Tenny Millhouse or someone on her behalf present? Okay, I have you come forward to the table. You can take a seat in those chairs. And while you do that, we'll have Ms. Holzer read in the case.
Thank you, Madam Chair. Our first case is number calendar number 25-173. This is at 12808 Summerland Road. Penny Millhouse, owner, proposes to erect a one-story frame, single-family residence deck, kitchen, and bedroom addition in an A1 one-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is one. With that, Madam Chair, I'll hand it over to Mr. Madison for the oath.
Thank you. At this time, we will swear in all those who are present for this case. If you're online, we'll come to you following those here in the room. At this time, do you swear and affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand. Spell your name, say your name, and provide your address for the record. We'll start right here with you.
Penny Millhouse, Tennie. Millhouse, Millhouse. Said address, 12808 Summerlin Avenue, Cleveland, Ohio, 44111.
Thank you. And you did say I do, correct?
I do.
Thank you.
I do.
We'll move over to you, sir.
Ronald Byrd, RONALD, BYRD, 12102, Tonnesing Drive, Garfield Heights, Ohio, 44125. I do.
Thank you. At this time, we'll move online. I see a hand raised by Paul. If you can unmute yourself and also provide the same information.
Thank you very much. Paul Began, last name B as in boy, EEGAN, from Began Architectural Design, 15703 Madison Avenue.
I do. Thank you. Is there anyone else?
No.
Seeing none, Madam Chair, I'll turn it over to you.
Okay, thank you for that. Can we go to history of the property, please?
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found that a permit was issued in 1955 to erect a single-family dwelling. 1957, a permit was issued to add a garage and enclose breezeway to a single-family home. There are no variances on file. And then in the more recent history, we see that in 2011, a permit was issued for a fence. In 2018, it seems that there were board-up permits issued to the property. And then in 2020, we see that there were building permits regarding HVAC, refrigeration, electrical. And that, again, that was in 2024. And that's all that I have. Thank you, Madam Chair.
All right, thank you for that. Can we have legal, please? We don't have Mary.
Okay, I'll read it, Madam Chair.
Okay.
Madam Chair, members of the board, appellant is requesting an area variance from the interior side yard requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. And Madam Chair, I should state for the people online that we are having difficulties this morning, technically wise. There's an issue with the server. So that might be the issue with Ms. Cornely this morning.
Okay, understood. All right, thank you for stepping in for Ms. Cornely. We'll now go to the project team. Do you want to have your architect speak for you, or do you want to speak first?
Yes, I would like the architect to speak for us, please.
All right, Mr. Began, you have the floor.
Thank you very much, Madam Chair. Appreciate your time this morning. Sorry I cannot be there in person to present for them. The house on Summerlin Avenue, the owner is looking to put an addition on the back of the house, primarily for an in-law type suite and to extend the kitchen for this house, really to make this house a little bit bigger and work better for their family. The addition is directly behind the house and does not extend any closer to the property line than the existing house. I do understand we're here this morning because of side yard setbacks, and we do have 10 feet combined, but as this is a single family district, we need a little bit more than that. So the existing house is 6 feet off the property line on one side. The addition maintains that building line moving back. And the addition does not extend any closer on the other side of the lot as well.
Okay, sounds pretty straightforward. Either of you have anything to add to that?
No, ma'am.
All right, any questions from the board? Madam Secretary, go right ahead.
Madam Chair, I do have several letters.
Okay,
If you'd like me to go ahead and read them.
please.
The first one is from Lizette Santiago, Reyes Santiago and Ferdinand Garcia Colon at 12710 Summerlin. They write to support the project. As nearby property owner, I'm writing to express my support for the variance requested by Tenny Millhouse regarding the proposed one-story single-family addition, including deck, kitchen, and bedroom. I understand that the request involves reducing the required interior side yard from 10 feet to 5 feet. I have no objection to this proposal. I believe the plan improvement will enhance the appearance and value of my property and could contribute positively to the neighborhood. Please record my support for this appeal at this public hearing, and they are at 12710 Summerlin. And the next is also a letter of support from the city planner, Nate Lull. He's writing to support the variance as the existing building line is being maintained with the addition. And again, that's Nate Lull, neighborhood planner for the Far West region. And then here's a letter of opposition from Kenyetta Harvey at 12805 Brooklawn Avenue. Let me make sure this is the right one. Yes, I'm writing to express my opposition to the variance requested. The applicant is seeking relief from the section 357.09B2 to reduce the required side yard setback from 10 to 5. As a neighboring property owner, I have several concerns about how this project may negatively affect my property. Regarding number one, loss of privacy. Reducing the setback would bring living areas and deck much closer to my home, creating intrusive sightlines to my yard and windows. Two, increased noise. Proximity to living spaces, especially a deck and a kitchen, will result in more noise being heard from my property, disrupting the quiet residential environment. Three, drainage issues. A small side yard raises concern about water runoff and potential drainage problems that could impact my property. And four, property value impact. This variance would alter established spacing between homes and could diminish the overall character of the neighborhood, reducing property values. I respectfully urge the board to deny this variance and maintain the existing 10-foot setback requirement, which helps preserve the privacy, safety, and livability of our community. And that is Kenyetta Harvey at 12805 Brooklawn Avenue. They do not state which property they own.
I believe that is probably the backyard, since it's on Brook Lawn.
Thank you. And that's all that I have. Thank you, Madam Chair.
Okay, so we have someone who has raised a few issues regarding your project. Do you want an opportunity to respond?
Yes. The addition that's going to be added to the property, the yard is very large. So I don't feel that this property is going to be an encroachment of the neighbor's privacy because of the distance is only going to be roughly 18 feet from the existing property. And there's roughly another 20 to 30 feet between where the property will be added on versus where her property line begins. She has a very large yard herself on the opposite side of the fence, and I don't see that being an issue with there being a problem raising any questions about privacy and or noise ordinance. The drainage will make sure that the gutter systems and the drainage is away from the property and that it's tied into whatever's necessary as far as the waste and storm. And we'll make sure that the property is graded properly to make sure that there's no encroachment of water onto the existing or adjacent properties.
Okay, thank you for that. Mr. Began, do you want to give comment as well?
Yes, just wanted to verify that, yes, 12805 Brooklawn is the neighbor directly behind here. And I know we have the map there, but I just wanted to make sure we pointed out that the closest distance from the proposed addition to the closest property line, it does go at an angle. There's almost 27 feet. And just looking at an aerial here, it looks like it's probably twice that distance to her house behind there. So I'm expecting probably 70 feet, 75 feet maybe from this addition to where the adjacent house would be on the backside. And noting also too that rear yard setback is not one of the issues we are before the board.
All right, thank you for that, Mr. Beegan. Mr. Bay, I know that Nate sent in a letter. Do you care to give a comment or do you want to defer to his letter?
Yeah, I don't have any additional comments. I'll just, we're all in alignment here. The house isn't encroaching into the side yard any greater, and there's still about 26 feet left in the rear yard. Thank you.
Okay, thank you, Mr. Bay. All right, I'll give one more ask to the board for questions.
Madam Chair, just one question for the appellants to articulate the difficulty you'll face if your variances are not granted today. Or your architect can also answer that as well.
Like the architect to answer that, please?
Sure.
Thanks, Ron. But give me the hard questions. Really, the hardship is here. These are relatively small homes in this neighborhood, right? Single floor, so the bedroom and living floor is on here. In order for the owner of this house to gain some space and open it up so that we have a ground floor in-law suite space with an extra bedroom. Obviously, as part of this, we're doing a kitchen expansion as well too, but it's really for adding that extra in-law suite space to make the house work better for their family. So really kind of the hardship is the only way that the owner could make this work is actually to leave their neighborhood and find a bigger house. Considering, the other houses in the neighborhood, a lot of them do have very similar additions as well too. So I don't think it's outside of the characteristic of the neighborhood to put a modest addition onto these relatively small houses.
Thank you. That's all I have.
All right, any other questions?
Mr. Beegan, just a quick question. This neighborhood, I believe, is mostly slab homes. Is that the case in this situation as well?
No, there is a basement in this house.
Okay. All right.
We're doing a crawl space under the addition, though. We're not extending the basement.
Okay, super. That's all I had.
All right, thank you, Ms. Faith. I'll entertain a motion.
Madam Chair,
I'll
motion.
make
Go ahead,
Okay.
Alana, please.
Okay. Madam Chair, given the fact that the issue before us is the side yard, not the rear yard setback, and given the testimony we've heard today, that the house is not going to exceed beyond the existing footprint, I move approval of calendar number 25-173.
All right, thank you, Ms. Faith. Is there a second?
Board Member Madison, second.
All right, can we call the vote?
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Mr. Madison,
Yes.
Ms. Faith,
Yes.
Ms. Wilson.
Yes.
Calendar number 25-173 is granted. It'll be ratified next Monday. We'll send you a letter, but you can contact us next Wednesday for further instruction.
Thank you.
Thank you very much.
You're very welcome. Good luck with your project. You're all set. All right, the next case we're going to call is calendar number 25-174. Do we have someone here from Leg Jack 2 LLC? Is there anyone present on behalf of Leg Jack 2 LLC? All right, I'm not hearing anyone in the room. I'm not seeing anything online. So I will move past this case and we'll try to get in touch with the appellant. So our next call, calendar number 25-129, is Muhammad J. Ali present?
I'm sorry, is that the case for 144, one that last one that you just brought up?
Yes, Leg Jack 2 LLC 3893 East 144. Okay, come on forward. That's okay. All right.
No, I'm the property, I board the property on 14405 Glendale.
So you're a neighbor.
I am a neighbor.
Okay, we would need the appellant.
Right.
Okay.
Okay. Yep. So hang tight. We'll try to get in touch with the appellant and we'll recall that case. All right. So then back to 25-129. Is there anyone here by the name of Muhammad J. Ali or anyone on his behalf? All right. Hearing nothing. I know that this case has been previously dismissed. So we'll recall. Oh, Chief Leonard, I can see that you're raising your hand. Please chime in.
I think a representative by the name of Iyad is on the phone for Mr. Ali.
Yes, I'm here in regard the address 10507.
Okay. All right. Perfect. Thank you for that, Chief Leonard. Ms. Hozard, I'll have you go ahead and read the case in, please.
Sure thing. Our next case is calendar number 25-129. This is at 10507 Superior Avenue, and it's a violation notice or an appeal to a violation notice. Muhammad J. Ali, owner, appeals under the authority of Section 76-6 of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the notice of violation number V25018731 issued on June 30th, 2025 by the Department of Building and Housing for failure to comply with Section 327.02B and C of the Cleveland Codified Ordinances, which state that there shall be no change, substitution, or extension in the use of any building or premises until the required use permits and certificate of occupancy have been issued by the Division of Building and Housing. Per Section 347.21, any establishment using 20% or more of floor, shelf, and/or display areas individually or in aggregate for the sale of smoke shop products is defined as a smoke shop and requires an application and approval from the Department of Building and Housing. This case was dismissed on August 25th, 2025 due to the appellant's unexplained absence. The appellant then contacted the office to explain the reason, and the board voted to reinstate the case. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, we'll swear in all those who are present for this case. We'll start here in the room and then we will move to those online. So we'll just start here with you, sir. I know that you're representing the city, but do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I'm not going to offer any testimony. I'm Chief Assistant Director of Law, David Roberts, Chief for Code Enforcement, and I'll just be here making legal argument and questioning Mr. Al-Fayyah.
Thank you. With that, we'll move online. I see a hand is raised for Mr. Jackson. Can you please unmute? Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please say your name, spell your name, and provide an address for the record. Oh, that's from the last case. Thank you. I appreciate that. Is there anyone else online or in the room?
I am.
Thank you, sir. You can just swear in at this time. Please just say your name, spell your name for the record, provide an address, and reply if I do.
My name is Iyad, E-Y-A-D. Last name is A-L-F-A-L-E-H. I'm presenting the address 10507 Superior Avenue, Ido.
Thank you. With that,
You're welcome.
Madam Chair, I'll turn it back over to you.
All right. Thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is appealing a violation notice issued by the Cleveland Department of Building and Housing. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right. Thank you. Mr. Iyad, can you go ahead and give us your comments, please?
Yes, please. The address at 10507 Superior Avenue, I understand there was some violations in regards some issues with the signage. However, we submitted an application, and I personally wrote on the application that it's not a smoke shop. However, we pursue the issues to fix all the violations on the outside as well as the inside. What we did, as a matter of fact, to obtain the occupancy as a volume discount place and wireless store, to fix on the inside. As a matter of fact, we did some fixing on the inside as requested by the fire department, And the next step, we're meeting with the inspector to fix all the violation on the outside. Like, for example, I understand there's some signage on the outside that will be taken down. There's some signage on the windows as well. It's gonna be taken down because the violation. And as we speak, we're in progress to fix all the violations. And it's not a smoke shop, 100%.
Okay,
Thank you.
thank you. And just to confirm, do you have the authorization to speak on behalf of Muhammad J. Ali today?
I'm the one I applied to obtain the occupancy. And my company, Neon City, has obtained the permit to fix all the violations. And he's the one who provided me with to attend the meeting on his behalf. And that's why
Okay.
I got the information and I logged into the meeting. And if
Okay.
you want, I could put him on the phone right now.
So there's a specific form that you are supposed to submit to our office that will give you the authorization to speak on his behalf. I just want to see if we have that on file, Madam Secretary.
No, we do not.
Okay. Can you have him log on?
Yeah, hold on.
Okay. And while you do that, I'm happy to turn it over to you, Mr. Roberts.
All right,
Okay.
Mr. Alfallah, my name is David Roberts. I am representing the city of Cleveland. You agreed, don't you, that there's no certificate of occupancy to make this a smoke shop, correct?
Oh, that is correct. It's not a
Okay.
smoke shop. Yeah.
Now, are you aware that a store is considered a smoke shop if it has more than 20% of certain products identified as smoke shop products?
Yes.
And the inspector said when he visited there was more than 20% by floor area or shelf space of smoke shop products. Was that right?
That is not correct. Mr. McMahon, the inspector, he just walked in to the store and he determined the accessories and all that. But if he took the measurements, I personally, which I did, it's less than 20%, even though they're doing some renovations on the inside and they're taking a lot of the hookah accessories down. But it's not 20%. It's less than 20%.
Well, are you familiar with what all the products are?
Yeah, I do.
Okay, and
The
so,
product contains of the 20% must be in HTCL, or the product which is written on every application to obtain the smoke license. And anything below the 20%, the law says that, you know what, it's not required. Because anyway, if you are a smoke shop, you're gonna end up with a 20%. So I don't understand that, you know what, some places that they have 20% and less, they don't need to obtain a smoke shop license. And the smoke shop license who obtained the license, that is still, it has to be 20%. So that's conflict.
so Mr. Alfallah, what are the 80% products that are for sale at 10507 Superior Avenue that are not smoke shop products?
Okay, they have a wireless place. They provide wireless services for all the companies like Alltel, Verizon.
Mr. Alfallah, that would be a service, right? But that's not a product sitting on a shelf to go toward the
I'm not
100%.
done. I'm
Okay,
not
go
done.
ahead. All
I'm
right,
not
please go
done.
on.
There's accessories on the shelves. They buy, sell phones as well. There's 2-3 showcases mounted against the wall with like a kiosk. They have all the accessories, the wall full of accessories. they have new phones, brand new phones, and old phones. That's one section. The next section, they sell all kind of TVs, video games and things like that. The other sections, they have hair product they sell. They sell hair product and accessories, which is next to the wireless. There's also 3 shelves on the floor that it has a product of grocery stores obtaining chips, candies, and all kind of stuff. There's coolers against the walls. They sell all cold product except beverages, except alcohol. They sell all kind of drinks, cold drinks, Pepsi, Gatorade, all kind of product. There's a small section which is two showcases. They sell a product of hookah product, and accessories. On the other sections, they sell, tobacco, cigarettes, which they have a license for that, and they sell also, a product, discounted product. Yeah, I've been in the place. I have measured it myself, and I have worked with the fire department. And the next step, as soon as they give us a release from the fire department, that they will move to the next step to meet with the inspector and fix all the violation. I understand there's as that picture, you see that location is over 5 years. The only thing they had a violations of for signage. Sure, there's some on the other side. There's old signs that says smoke shop. That's before the law, before the mess started in the Cuyahoga County. So the next step, I'm meeting with the actual inspector who's in charge of that area. But see, you have a conflict of all the inspectors. You have like 2-3 inspectors. They went and they issued a violation for the same product. I think they should be more organized in the inspector department. So who shall I contact in regards fixing all these issues? It should be for that ward, for that location, one inspector. But McMahon, he jumped from Lee Road to Superior to the west side. I don't understand. Even though they have him on video when he walked in, he did not even bother to talk to none of the employees or or contact me direct. I worked with him, but this is unprofessional and it's unacceptable. Everybody writes violations, and we have to follow up with the city of Cleveland. Yeah, sure. We have taken the first step in regards to the issues, and we're fixing it as we speak. That place is not a smoke shop. Even though, you know what? It's a mess from the beginning in the city of Cleveland, because you want people to obtain a smoke shop, but you know what? In regards, they go through the whole procedures and the 9 yard and all the requirement, and you have a grocery store that they have 10%. Even though the unauthorized smoke shop, that you know what? All what they have to do just to throw some product inside the store, and there you go, they became legal. So I don't understand the law or the licensing itself. This guy's been there for over 7 years. He's been occupying the place, and he's been selling the wireless. You could see the signs. It's old signs. Yeah, it needs some, it needs some renovation. It needs updated. Yeah, and we're willing to work with the city. But for you to consider it as a smoke shop, no, it's not a smoke shop. And I challenge anybody, and we could meet at that location at any given time. All what we want to correct the violation of unauthorized occupancy for a wireless place and discount. That's all. And we should work together to fix all these issues.
All right, thank you for that. Do you have any
Yeah,
additional?
Mr. Alfalay, what percent of the floor area or shelf space is devoted to smoke shop products?
I would say about 15 to 18%. That's it.
I have nothing more, Madam Chairman.
Okay, and by any chance, did the inspector take any photos to substantiate the claim that
he's-
there's over 20% smoke shop items there?
He may have taken photos, but we're not here presenting them, so you should defer to Mr. Alfalay's testimony.
Okay. Do you have any photos by any chance, Mr. Alfalay, that would show what the floor area has?
I sent to Shannon the floor plan, but you know what? On hand, I was notified on Friday that I have to attend this. Otherwise, I would go take. Even though we're doing renovations, regardless, he's taken all the accessories for the hookah, and it's gonna be even though smaller because you know what? It's not a good selling product in the in his area. So he had it, and I highly doubt it's gonna be probably less than 10%. Less
Okay.
than, even though
All
probably
right.
a showcase or two showcase. That's it out of the whole total area. And we're working with the city. It's not like we're ignoring it.
So
The
question,
violation that
how
not
how
having
many, hold on one second, how many showcases do you have in the store?
how many showcases?
Yeah.
See, there's like a horseshoe showcases. Two showcases, they have the accessories of the hookah product. The other two showcases, they have the T-shirts, and the other two showcases have candies and product like that, discounted product. That's it.
So you have 6 showcases in the store?
Yes, that's
Okay.
in one
Any-
section. No, that's in
Okay.
one section. The section wireless has a big, huge showcase. It has accessories. There's the hair product also, the hair product section, which is it occupied 25%. You have 25% wireless, and you have the 3 showcases, long showcase. I mean, 3 shelves on the floor, and a huge. It occupied about probably, I would say about 30 to 40% of the location, and you have the cooler about another 10, 15, 12 percentage, and
Okay.
and I could provide you with the existing, but the reason of occupying that place is to get an occupancy and do renovation on the inside and fix all the issues, not as
Okay.
a smoke shop, even though, you know what, the state has abandoned you know, like the product that is supposed to be sold, and which is, it's, I know sooner or later they're gonna abandon it, you know,
All
so
right. Thank you, Mr. Alfalay.
regardless, it is less than 20% that he has as a smoke, and he's gonna take it out to minimize it probably to 10%.
And more. Got it. All right, I'll turn it over to the board. Any questions from the board?
Yes, Madam Chair, I have a few. To Mr. Roberts, does the appellant have the certificate of occupancy they need to sell products other than smoke shop products?
As far as I know,
So the only issue here is they don't have the certificate for the smoke shop products, and they, according to the city, had more than 20% of those products in the store at the time of the inspector's inspection. Is that correct?
that the inspector is notice was based on the fact that he observed more than 20%, but you've heard today from Mr. Alfalay that he's testifying it's not more than 20%. I would indicate on behalf of the city, the purpose of the notice was to make sure they're in compliance. And Mr. Alfalay has said, in good faith, they're removing the hookah products. It's possible that that takes them under 20 when they were over 20. But their only evidence here today is from Mr. Alfalay that it was always less than 20. So the city's not concerned if you grant the appeal and indicate that we haven't proven He's proven that there was less than 20 at the time of the inspection. If there's more than 20, we'll return, we'll provide pictures, we'll fight the fight. But I trust Mr. Alfala. He's saying they're going to
Appreciate you.
reduce the amount and get into compliance. He's also indicated complying with other parts of the notice. So we're happy to see this granted by the board.
And then
Okay.
just, what is the penalty if this violation stands and he does not comply? What's the financial penalty? Or, I mean, obviously he can't sell smoke shop products.
No, but you're correct. If the finding of the board is that they're in violation, then for every day after that, when they didn't stop selling more than 20% smoke shop products, they would be subject to a criminal prosecution, first degree misdemeanor, $1,000 a day fine at the discretion of the judge, or potentially a civil ticket for $200 for every day. So there is a powerful effect if you uphold the notice, although I'm not actually alleging that they didn't cease once the inspector gave the notice. But you're right, there is a serious effect if you don't grant the appeal. So we're happy to see you grant the appeal.
All right. Any other questions from the board?
Yeah, just, Madam Chair, through you to, the individual that just testified. Does what you just hear, is that clear, you know, as it relates to the penalty of not coming, or having products above 20%? So, you know, we're hearing your testimony today, and it sounds as if you guys have taken some steps to be in compliance. But if for some reason it comes back, you know, before the board or the body, and it shows that changes haven't been made, there is penalties to that. Are you aware? And can you just confirm that you just heard what we just heard as well?
Absolutely. We're here to fix all the issues. I have walked with the fire department through the inspection. There was some issues in the building on the inside. We have fixed all the electric, whatever was requested by the fire department. The moment they give us a sign off on the fire department, pass, what I will meet personally. I will contact the inspector, and we'll go through the building on the outside and the inside, and whatever needs to be done, we will comply. I mean, we live in Cleveland, and we want to make sure that, we're complying to help the small businesses. But me as advice personally, there's a lot of businesses out there that, they don't have, they existed, but they don't have the right occupancy or the, permits for signage and things like that. And I think you should have more sense in with the inspectors, because whether we agree or not, it's a mess out there. It's like a zoo with no fence around it. And I think it should be more organized. Seriously.
All right. Thank you, Mr. Alfala. I'll ask
You're
the board if there's any additional questions before we move to a vote. All right, I'll entertain a motion.
Madam Chair, based on the testimony we've heard today from both the city attorney as well as the appellant's representative, I should say, I move that we reverse the administrative decision.
All right, is there a second?
I second, Madam Chair.
All right, thank you, Ms. Faith. Can we call the vote?
Ms. Holzer,
Yes.
Mr. Madison,
Yes.
Ms. Faith,
Yes.
Ms. Roca,
Yes.
Ms. Wilson.
Yes.
Calendar number 25 I'm the wrong one. 25-129 is granted. This will be ratified next week, and we will send the appellant a letter.
Appreciate you. Thank you for your time.
All right, you're quite welcome. We're going to call the next case, which is calendar number 25-146. Do we have someone present from Glenville Plaza Holdings LLC? All right, we'll have you come forward, and while you do that, we'll have Ms. Holzer read in the case.
Our next case is calendar number 25-146. This is at 10324 St. Clair Avenue. Glenville Plaza Holdings LLC owner proposes to expand use to include a smoke shop in a shopping center zoning district. The owner appeals for relief from the strict application of the Cleveland codified ordinances as stated in the agenda and the public record, of which there are two. This case was postponed from September 15th due to a lack of 5 board members being present. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, I'll swear in all those who are present for this case. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, say your name, spell your name, and provide your address for the record. We'll start here with you.
Ashley Watson, ASHLEY, WATSON, address 10324 St. Clair Avenue, Cleveland, Ohio, 44108, and I do.
Thank you. We'll move over to you, sir.
I'm Mark O'Brien. I'm attorney for Glenville Plaza Holding, and I'm here representing the tenant also, Savvy RSS Corp. Savvy Smokes, which is the tenant that operates the business shopping center.
Thank you. Can you just spell your name for the record?
Mark, it's O'Brien, capital O, apostrophe, capital B, RIEN.
Is there anyone else online present for this case? And just for the record,
And I'm David Roberts, Chief Assistant Director of Law for Code Enforcement from the Cleveland Law Department, here to inquire of the witnesses and make legal argument.
with that, Madam Chair, I'll turn it back over to you.
All right, can we go to history of the property, please?
Thank you, Madam Chair. The property was originally zoned general retail in 1929. In 1977, it was changed to local retail business. In 1987, it was changed to the shopping center district. In our Records Administration Office, we found that in 1989, a permit was issued to demolish a one-story commercial building. In 1990, there was a permit issued to erect a one-story multi-tenant retail building. There's one Board of Zoning Appeals case on file in BZA calendar 90-323. This board granted variance to erect non-conforming wall signs for a Rite Aid. And Madam Chair, that's all that I have. We do see that there was a violation notice issued in June of this year for exterior maintenance to the property. And that's all that I have. Thank you.
All right, thank you. Can we have legal, please?
Madam Chair, members of the board, appellant is requesting area variances from the minimum distance and permit application requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
All right, thank you. I will now turn to either of you that wants to speak first. Just state your name and go ahead and give your comment.
Thank you. State your name, please.
Ashley Watson.
And Ms. Watson, what is your relationship to the subject property?
I am a tenant and also a co-owner of the business.
Okay, so you're co-owner of what business?
Savvy RSSS Corp.
Okay, and that is the owner of Savvy Smokes. It's the tenant at Glenville Plaza Holding at 28038. I'm sorry, at 10324 St. Clair Avenue. Is that correct?
That is correct.
Okay, and what kind of business is this?
It is a smoke shop.
Okay, when you heard Mr. Roberts before talking about 20% requirement, what percentage of the products you sell are smoke products?
I would say probably around 70, maybe 60 to 70.
So you acknowledge that this is covered by the relevant ordinance, correct?
Oh, absolutely.
Okay, and how long has the business been operated at this location as a smoke shop?
We have been in existence since 2014 and we relocated to the Glenville Plaza in 2017. So 8 years there.
Continuously?
Yes.
Okay, and you've been operating in this way for that entire 8 years?
Yes, no breaks.
And what brought you to file your permit application in this case?
Due to the implementation of the new laws, I guess this past spring is when inspectors were going around. So that was our first time being made aware that this was even an issue.
Okay. And that's when you filed this application requesting these variances, correct?
Immediately.
And do you have you been given any other correspondence that in support of your variance application?
Yes, I have received a letter from the representative of the daycare center, which is also in the plaza, and then also a letter of support from the councilman of our ward.
And the councilman is Kevin Conwell, correct?
That is correct.
Okay, and he supports your, the variance that you're requesting in this case, is that correct?
That is correct.
Okay, and so does the tenant who operates the daycare center, correct?
That is correct.
Okay, I'm gonna submit these to the board then. Call them, I guess, exhibits A and B. Robert, first, I have more. You want these? Yeah. Oh, if anybody else wants, I got more copies too.
Okay.
And why are you requesting these variances?
Requesting the variances because otherwise I believe that we would have to close business and
Relocate.
absolutely, which would be a hardship as well due to the laws.
And you have a lease currently with Glenville Plaza Holding, is that correct?
Yes, that is
And
correct.
how long does that lease run?
We renewed the lease. I believe the new one is up in 2027, and then we have paused on renewing the lease until after this process is over for another 5 years.
You acknowledge you'd be in violation of your lease if you were forced to no longer run that business.
That is correct.
Okay. Thank you. No further questions at this time.
All right, Mr. Roberts, do you have the floor?
I don't have any questions from Ms. Watson. Look forward to hearing from Mr. Bay.
Okay, Mr. Bay.
Good morning. My name is Xavier Bay, representing city planning. We do have a few slides here representing the saturation maps for the area. And so the map displayed on the screen currently, you can see the star shape indicates the property of discussion. This property is within 2 miles of 2 existing legally established smoke shops and is within the 500-foot buffer of multiple churches and daycares within the area. And for that reason, we do not support the use of this property for a smoke shop. And that's primarily because the purpose and intent of this code section that we passed in April of this year to regulate the location of smoke shops, to protect the public health, safety, and welfare of all Clevelanders, to protect neighborhoods from negative externalities and secondary effects created by the concentration of such businesses, and to avoid and reduce oversaturation of these types of businesses. Thank you.
All right, thank you, Mr. Bay. Any questions from the board?
Yes, Madam Chair, just a question regarding this map. So where the green dot is where the smoke shop currently is, and the star that's there, what is that again?
So the star here on the screen is the Glenville Plaza, the property that we're talking about today. And then the green that you see just up the street here at 10643 St. Clair is a legally established smoke shop. But this previous map here actually gives you kind of a greater context of other legally established smoke shops nearby. So these other green dots on this map display legally established smoke shops near this location. But these red circles are the end line of the 2-mile buffer. I know this map does look a little it looks a little busy, but basically this star shape is where the property of interest is, and the green dots show you where the other nearby smoke shops are. This map here on the screen now primarily indicates the places of worship, daycare centers, and schools.
Thank you. And Madam Chair, just a follow-up question. Can you, just for the board and for the individuals here today, what's a legally established smoke shops as it relates to the map that you have here?
Sorry, are you asking?
How is that determined?
Yes, so when somebody submits a building permit application, it goes through review. And so typically, basically, before the date that this ordinance was established, 4/14/25, these permits could have been in process. And so then if they submitted their permit before the effective date of the new legislation, then they would be reviewed under the pre-existing zoning. But if there's an application that was submitted on that date or after that date, they'd have to, abide by the zoning code with the 2 miles from other existing smoke shops and 500 feet from schools, daycares, churches, parks, and libraries.
Thank you.
Answer your question?
It does. Appreciate that.
I'll defer to
Madam
Shannon
Chair.
Leonard if you have any extra questions.
I do have a question,
Chief?
Madam Chair.
Okay, go right ahead.
Yes, ma'am.
And this is for Chief Leonard or Xavier. If I recall correctly, there was a process for existing smoke shops to submit documentation to be grandfathered in. And just curious if A, that is correct, and what the process was for notifying existing businesses so that they could have that opportunity to be grandfathered in.
Yeah, good morning, Madam Chair, Chief Shannon Leonard, Chief Zoning Administrator. So the ordinance that went into effect was a culmination of several months pushed by Cleveland City Council in terms of reining in the saturation and oversaturation of these smoke shops across the city. And so there was a lot of news articles that were out there. There was news of this legislation being contemplated. And so once that news went out, people ended up submitting several applications across the city to essentially establish use as a smoke shop. However, regardless of whether you're a smoke shop or a wireless store or a candy shop or a daycare, you need an occupancy permit for the use for which you're using your business as to legally operate a business within the city of Cleveland. And so there's no record of, I believe, an occupancy permit for a smoke shop at this location. And it is within that proximity in the same shopping center as a daycare.
All right, thank you for that, Chief Leonard. I'll turn to the appellant. Do you have any record or any explanation as to the lack of having a certificate of occupancy?
Our argument is that this is a pre-existing non-conforming use. This shop was in existence as a smoke shop for years before the law was passed back in, I think it was April, by Cleveland City Council. And as such, City Council is without the authority to require a new permit, a new application for a permit for a smoke shop. That any use of property that was in existence before the law was passed is in essence, as the prior person said, it's grandfathered in. And that is well-respected law in the state of Ohio that the city cannot essentially unzone a pre-existing use that existed prior to the time of the enactment of the ordinance.
Okay, so I want to just re-ask my question. So we just heard from Chief Zoning Administrator, and she stated that there is no certificate of occupancy on file for this business. So I just want to turn to you all to see if you have any comment or if you have any record of there being a certificate of occupancy, and maybe there's just a mistake somewhere.
I believe, go ahead.
Madam Chair, the previous use for this occupancy that was on file from 2016 was for a pharmacy. And so when you change the use, whether that's to a smoke shop or a candy shop, you need to establish use for your specific use. And so there's nothing that was grandfathered in here. If they were a pharmacy at the date of when the legislation went through, then they would have been grandfathered in as a pharmacy. But prior to that, anything that's not on file legally as a certificate of occupancy is not grandfathered in.
Understood.
That was for a different property. I think that's a pharmacy that's being referred to is actually on the corner of the shopping center. It's not for this space. And our argument is simply that it is not there. It's regardless of whether or not there is a permit on file. As long as the use was pre-existing, the city cannot therefore outlaw the pre-existing use.
Do you have any evidence to contradict the fact that there is no permit on file for a smoke shop?
No, I don't believe so.
Okay.
I did have a comment and then a question. So I do want to reiterate that the pharmacy is actually in a different parcel and has always been of the plaza. And the space that we're occupying, and we've again been there for over 8 years, has always been retail. So there was no need to change the use, and the by the time, well, when we secured it to open up as a smoke shop in 2014, I don't believe like these regulations and rules were, like in place to even apply, to my knowledge, for a permit as a smoke shop, like that's a newer thing. And so I did believe that we were grandfathered in. And also, to, I think the chief's point, or someone's point, maybe Mr. Madison made it about notifying of the process of converting over for those who are pre-existing. We've received no notification to have that be something that was necessary to be done. So I do believe a lot of these newer shops that are just popping up that don't have the long history and standing and duration and support that we have, not just from the community, but even our neighbors, and also the history of no record or no non-compliance prior to this, were given the opportunity to grant these permits because they're applying as new businesses. So I believe that if that's something that I would start today, I would know that that process needs to be, or that permit needs to be received or obtained rather, but that's not something 10 years ago that was in place, if that makes sense.
Okay, thank you for that. Chief Leonard, I can see your hand is raised. Do you have additional comment?
Yeah, so I will defer to Chief Roberts to clarify the permitting process, but and how new regulation works within the city of Cleveland, is in terms of pre-existing uses that are not legally established, because essentially, all of the smoke shops that are coming through the city that are that did not have an occupancy permit is the same argument that this is. You cannot regulate us because we were here before that legislation passed.
Okay, I'd love to hear whether, if she had applied in 2014, could she have gotten an occupancy permit for a smoke shop?
Yes.
Okay.
And to reiterate what Ms. Leonard is saying, no, Mr. O'Brien is wrong about the law. It's not that you pre-existed. It's that you pre-existed with legal authorization, which is established under our zoning code through a certificate of occupancy. So even if you were there prior, if you didn't get your certificate, you weren't yet legal. And so you don't get the right to be a prior legal non-conforming use. You're a prior non-conforming use, but not a prior legal non-conforming use. And so I would also like to indicate, I don't know if you want to hear from Mr. Bay on this, or we could ask Ms. Watson. I don't think there's anything about this location that is unique in terms of this hardship. Any other portion of that pink or any portion within the circle by that approved smoke shop faces the same difficulty, which is there's a law now that says we don't want so many smoke shops. And so we're not allowing them near schools and churches, and we're not allowing them near existing smoke shops. So there's nothing unique presented by the appellant today to support the variance.
All right, any questions from the board? Chief Leonard, I can see that your hand is raised. Is that a new hand?
That's an old hand, I'm sorry.
Okay, that's okay. Board members, any questions? All right, I'll entertain a motion, please.
I'll take it. Based on the testimony that we've heard today, I'm in calendar number 25-146. I move that we uphold the administrative decision.
Wait, I think this is actually a
Oh, I'm sorry.
variance.
They're seeking variances.
Excuse me. I move that we, wait, now I'm confused myself. That we deny the variances.
All right, we've got a motion to deny. Do we have a second?
Board Member Madison, second.
All right, can we call the vote?
Ms. Faith?
Yes.
Ms. Holzer?
Yes.
Mr. Madison?
Yes.
Ms. Roca?
Yes.
Ms. Wilson?
Yes.
Calendar number 25-146 is denied. This decision will be ratified next Monday, and we will send the appellant a letter.
All right, that concludes this matter. Good luck with your project. We'll now circle back to calendar number 25-174. I believe we had someone join us online from Leg Jack 2 LLC. Is that correct? Dominique Jackson, are you here for Leg Jack LLC? All right, we can see that your video is on, but I cannot hear anything.
Can you hear me now?
I can hear Miss Elizabeth Jackson.
Correct.
Okay, I'm looking to hear from Dominique Jackson.
I don't know if she has the ability to get on the mic. The mic
Are
is being
you from
unmuted.
Are you from Leg Jack 2 LLC, Elizabeth?
Yes, I am the administrator of that in unit.
Okay. All right, we'll go ahead and read in the case since we have you all here, and hopefully Dominique can get her audio issue resolved. Ms. Hoser, you want to read us in?
Yep, our next case is calendar number 25-174. This is at 3893 East 144th Street, Leg Jack 2 LLC. Owner proposes to establish use as a residential facility for 5 occupants in an A1 one-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 2. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, we'll swear in all those who are present for this case. We'll start here in the room and then we'll make our way online. Do you swear and affirm that the testimony you're about to give is the truth and nothing but the truth? Please raise your hand, say your name, spell your name, provide your address, and reply if I do.
And turn your mic on.
Thank you.
My name is Scott Stevens. That's SCOTTSTEVENS. That's 14405 Glendale. That's Cleveland, Ohio, 44128.
And I do? Did you say I do?
I do.
Thank you. All right, at this time, we'll move to those who are online. There's a couple of hand raises, so I'm not sure who is speaking, but please unmute and say your name, spell your name, provide your address for the record, followed by a do.
Dominique Jackson, DOMINIQUE, Jackson, JACKSON.
Your address, please.
4114 East 141st Street, Cleveland, Ohio, 44128.
Thank you.
Ms. Jackson, do you swear to tell the truth?
Yes, I do.
And we see that there's another hand. Can you please just swear in as well that you affirm that the testimony you're about to give is the whole truth and nothing but the truth?
Yes.
Oh, no, I'm sorry. I think I'm speaking to, I can't read the name from this distance, but
Elizabeth.
Elizabeth?
Yes, hi. My address is 19343 Ackerman Avenue, New Hall, California. And yes, I do swear to say the truth, to tell the truth.
Can you please just spell your name for the record?
ELIS as in Sam, ABETTA.
Last name?
Jackson?
Oh, thank you. I think we can get that. With that, Madam Chair, we'll turn it back over to you.
All right, thank you, Mr. Madison. Can we have history of the property, please?
Yes, Madam Chair, there's been no change in the zoning since 1929. In our Records Administration Office, we found that in 1945, a permit was issued to erect a dwelling. 1947, a permit was issued to erect a private garage. 1962, a permit was issued to erect a fence. There are no variances on file and nothing of note in the more recent history. That's all that I have. Thank you.
Thank you. Can we have legal, please?
Madam Chair, members of the board, Appellant is requesting an area variance from the minimum distance requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
All right, thank you for that. Who wants to speak first? Will it be you, Dominique, or Elizabetta?
Me.
Okay, go right ahead.
Yes, I'm currently a peer supporter for People, Places, and Dreams. I work with mental health, illness, and drug abuse. And I'm trying to open up a residential home to better the community for drug abuse and to better myself with this business.
All right, can you tell us about your business plan?
I'm opening up a residential house. I currently have residents that's ready to move in. I already have everything I need inside the unit. I just need my fire extinguishers. The house is already up and running, can be up and running to be a residential home. I have my beds in there and everything I need.
What's your staffing plan?
Staffing plan, like as what?
As in, how many staff are you gonna have on hand to operate this business?
I'm gonna be working there as myself for now until I get a lot of clients in. But my staffing will be like 1 or 2.
Does that 1 or 2 include you?
Yeah.
Okay, and what are the hours of operation for the facility?
It'll be 24 hours. It's a residential home for them to live.
Okay, do you have any additional comments or details you want to share with the board?
No.
All right, Elizabetta, you have the floor. Go ahead and give your comment.
I mean, I'm kind of stunned. I don't know exactly what are you looking for, but Dominique is our niece and my husband and I niece. And when this opportunity came along, we supported her and said, sure, absolutely, we'll support you. And we are looking in the betterment of the young lady and frankly of the area.
All right, thank you for that. I'll now turn to you, Mr. Scott Stevens. You have the floor.
Yes, I'd like to know the tenants that you're bringing, the tenants.
Hold on, yeah, turn your mic
Sorry.
on. And the conversation or comments that you have are directed toward the board.
Okay. With now she says she's bringing in mental health tenants or people who's trying to recover from drug addiction. Is that what
Yes.
is that the tenants?
Yes.
And this is going to be a 24-hour thing?
Okay, I need you to
Yes.
just give us comments. Just tell us exactly what it is that you want us to know about your position on this residential facility.
I don't really have any questions about it. I just wanted,
Your thoughts about it.
no.
Okay,
Mm.
and are you a neighbor of this?
Yes, I am.
Okay, and do you support having a residential facility in your neighborhood?
No.
Okay, and do you want to tell the board why that is, or do you just want to leave it at that?
Well, I'll just leave it at that. I like the privacy of my home. I don't want any other issues as far as like drug related issues. I know they're trying to recover from trying to help them or recover from and give them a place to stay. But it's been fairly quiet over where I am. And I just don't want any issues with that. I've always had peace at that home over there. So
Okay.
that's it.
All right. Any questions from the board?
Madam Chair, I would just, if we were moving to Mr. Bay, I would love to see the saturation maps.
Oh, of course. I just want to make sure there's no other questions from the board. All right.
And
Ms. Hoser?
may I say just a few lines about
Hold on
the
1
function
second.
of a neighbor?
Elizabeth, hold on 1 second. Ms. Hoser, were you gonna chime in?
I did have a couple of questions.
Okay.
And I believe, so my understanding is that Leg Jack 2 LLC is owned by Miss Elizabeth Jackson. Is that correct, Ms.
Correct.
Jackson?
Yes.
I'm curious what the property has, what the current use is of the property.
Right now, nothing, because we used to rent it, but not in the last few years because we rehabbed the house completely. My husband did the work. We redid the driveway, every single floor, the bathroom, everything inside the house has been redone. Our next thing to do is do the outside siding and the awning, but as you can see, it's raining in Cleveland and it's not a good time to do that. We have to wait until the weather is going to be a little better.
And Ms. Jackson, were you rehabbing the property with the intent of using it as a residential facility, or was it being rehabbed for another use?
Yes, it was getting rehab for being a residential too, housing.
Yes, we will, our intent was to help Dominique in this endeavor.
And were you aware that you would need to get the property rezoned in order to get this use?
At the beginning, I wasn't, but then I became aware, when we researched more. So yeah, we found out that there were more things to be done.
And my last question to Ms. Elizabetta is, if the variance is not granted, what hardship would you experience as the property owner?
Well, definitely, that would have put a dent in all these months of the house being ready and not able to rent it. So yeah, definitely would be an economic hardship. Also, we are looking into invest more in that area to better that area, since my husband grew up there since he was a few years old and he is emotionally connected to it. So, yeah, sure. It's a hardship, definitely financial.
Okay, Madam Chair, those are my questions for now.
All right. Thank you, Ms.
Madam
Hoser.
Madam Chair, I also have a couple of questions.
Mhm.
So we'll just start here. Can you just tell us again how many bedrooms are in the house? And how many individuals are you looking to keep or to recruit?
It's 3 bedroom. I think it's eligible for a 5-bed house. But it might be a 4.
So 3 bedrooms, but there's 5 bedrooms that you have, so you're looking to recruit 3 individuals to live in this space?
3 to 5, because the 2 bedrooms is eligible for 2 beds to go in, and the 1 room is eligible for 1 bed.
Okay, thank you. And then what is your recruitment plan for identifying individuals you would like to provide this service for?
See, I work at People, Places, and Dreams, so we already really have the clients. We're trying to move them into a home so they can be safe.
Thank you. And then what is your security plan in terms of just not only keeping, yourself safe, but the individuals that will be housed as well as those in the resident, the neighborhood?
I would have somebody there to watch over the house, and I'll have a Ring camera.
And will the individual be there 24 hours or is it?
No, they won't be there 24 hours. They're able to go to activities, workshops, different places. They would be out with their peers in the community, going to AA meetings and different meetings and IOP programs.
I think the question was a little bit different. You stated that you were going to have someone there to watch over the house. And the question is, the person who's going to watch over the house, how many hours per day will they be there watching over the house?
See, I'm gonna be there in the morning. I'm gonna have them there at night and probably in the evening.
So I would say probably we are thinking about, for what she explained to me, she's thinking about 18 hours of watch over. There will be just a few hours, like in the late morning and early afternoon, that is not covered.
All right.
Thank
Does that
you.
cover your questions, or you have more?
Madam Chair, I just have two more.
Okay.
Can you also just share with us your experience running a facility of this nature before?
No,
Or do
I
you
don't
have
experience.
experience?
I don't have experience, but I'm currently a peer supporter, so I go with them to their homes, and I done seen how their homes are worked. Like, how do they work their homes, and how, like, I work with peer, I'm a peer supporter, so I deal with them clients every day.
I'm sorry, Madam Chair. It was, you were breaking up a little bit. Was your did you say that you don't have experience running the home, but you have experience being a peer support?
I have experience being a peer supporter, and I have experience working in a group home before.
Thank you. And my last question is, do you plan to go through the Ohio Department of Mental Health and Addiction Services for any certifications or licensures?
Yes, I do. Yes, I do.
And what are they?
I have to get the permit first before I even put my application in.
Okay, thank you. All my questions.
Thank you for that. Mr. Bay, do you have comment?
Good morning again. This is Xavier Bay representing City Planning. On the screen right now, I'm displaying a saturation map of the neighborhood, but I actually also have one of the greater ward, Ward 2. And so I'll start off here. The star indicated on the map here that I'm circling with a hand icon is where the proposed facility is located. And then you can see the blue outlines here show you ward line designations. And so this property is within Ward 2. And this map is primarily just displayed to show you the oversaturation that's occurring in Ward 2. And then this map here, I have a closer view of the neighborhood that the property is located in. And again, the star indicates the property in question. And so you can see here that this property is within 1,000 feet of an already existing residential facility and is just outside the buffer of 2 additional facilities. And mainly for the reason of oversaturation is what we're going to stand in opposition of the request here. We definitely are appreciative of the applicant or the landowner, keeping up the property, and we believe, there's other uses of the property as far as, residential single-family use. If the property were to be used as a 2-family, we would support that variance and another hearing if that were the case. We're also open to working with the applicant to understand where residential facility could be located as far as, advising them through our GIS map to see what other opportunities there are throughout the city of Cleveland that are outside of 1,000 feet of already existing facilities.
All right, thank you, Mr. Bay. So in looking at the saturation map, is it fair to say that the home that is within the same circle as the applicant's home, is that on the same street?
That is correct, Madam Chair.
Okay, thanks for confirming that. Any other questions from the board? All right, I'll entertain a motion.
May I say something?
We're actually going to go to a vote. I'll give you a brief 15 seconds to give your final comment.
Just to comment on what the neighbor has said, if there is already such a saturation and the area is still very quiet, I don't think that having one more is going to make a difference in problem with anybody.
All right, thank you for that. I'll turn it back to the board with a motion for this calendar item.
Madam Chair, based on today's testimony as well as recommendations from city planning, I move to deny the following request of calendar number 25-174.
All right, thank you, Mr. Madison. Is there a second?
I second.
All right, thank you, Ms. Faith. Can we call the vote?
Ms. Holzer,
Yes.
Ms. Roca. Yes. Ms. Faith,
Yes.
Mr. Madison.
Yes.
Ms. Wilson.
Yes.
Calendar number 25-174 is denied. This decision will be ratified next Monday, and we will send the appellant a letter.
All right, thank you so much for being here. Good luck to you. All right, we're gonna move now to the final calendar number of the day, which is 25-132. Do we have Raymond Perez present? Oh, Jocelyn Perez, are you here on behalf of Raymond?
Raymond Perez is present.
Oh, okay. The screen name said Jocelyn.
Sorry, Jocelyn Perez is present also. You said my name. Good
Okay,
morning.
both of you are present. Okay, great. I'll turn to Ms. Holzer to read in the case, please.
Our next case is calendar number 25-132. This is at 1944 West 48th Street. Raymond Perez, owner, proposes to establish a Type A daycare in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are two. This case was postponed from August 11th, 2025 and October 6th, 2025 due to a finding of res judicata and to allow time for a transcript of the 1990s case to be produced. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, we'll swear in those who are present for this case. We'll be moving to online. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? At this time, please take yourself off of unmute, say your name, spell your name, provide an address for the record, and reply with I do.
Okay. Raymond Perez, RAYMOND PEREZ, and I swear to tell the whole truth.
Can you provide your address for the record?
I'm sorry. 1944 West 48th Street, Cleveland, Ohio 44102.
Thank you. Is there anyone else online that would like to speak?
Yes, that's me, Jocelyn Perez, JOSELYN, Perez, PEREZ. Address is 1944 West 48th Street, Cleveland, Ohio 44102, and I do.
Thank you. Anyone else? Seeing none, Madam Chair, I'll turn it back over to you.
All right, thank you for that. Can we have history of the property, please?
Thank you, Madam Chair. This case involves a previous variance that was denied in 1996. So I'm going to read some highlights from the transcript that we acquired from that hearing. The appellant at the time was Iris Perez, and Margie Colon and Nicole Stevens were present to speak with Iris Perez. The variance issues were the same. The code required a 30-foot distance from neighboring premises, and the appellant did not have that distance. At the time, the appellant was requesting a daycare center in the building. The history of the property at the time, and of course still remains, that in 1928, a permit was issued to convert from a single-family house to a two-family dwelling. In 1929, the property was placed in a two-family residential district. And then there is another BZA case in calendar 72-54, where this board granted a variance to change the use to a three-family. Now, the one that I'm reading from is calendar number 96-185, where this board denied the variance for a daycare. The appellants go on to explain, the city explains the zoning issues in this transcript. And then the appellant explains that it is going to be a daycare center, but they are not asking for 15 to 16 children. They were only asking for 8 children at the time. And that they proposed that their pickup and drop off would take place in the driveway and on the street in the front. The appellant stated at the time that the neighbors had no problem with it. And then the board members stated, and this would be Schwanek, she stated concern about the drop off and pickup for the children. And it was noted by the Ms. Cologne, who was part of the project team, that the pickup and drop off again would take place in the long driveway. But then Ms. Schwanek, the member, stated that that there was concern that there's only one way in and out of the driveway, and that somebody dropping off the child or children would be able to pull in, but nobody else would be able to pull in behind them at the same time. And there would be an issue if there were two or more cars coming at once. So the city planning representative stated that the staff find at the time no hardship where these conditions would warrant granting of the variance, as they feel it would be out of character with the surrounding areas based upon a two-family residential dwelling. They also feel that the traffic generated by the pickup and drop-off would have a negative impact on the area. Again, that they stated, as the board members stated, that their concern is that someone who is going to be dropping off someone or a child, they're not pulling into the driveway unless there's a circular driveway, and that they can pull in and pull out easily. And so city planning recommended denial at the time. Ms. Perez stated that she had a letter from the neighbor across the street of support. And the name of the neighbor was Trevino. That was Mr. and Mrs. Trevino, and stating that they both have no objection to the variance, as they have a very clean and good yard and would be okay to convert to a daycare. Then board member Pekosik stated that he feels that this would have a negative impact in the area, especially in regards to traffic and parking, and therefore would not approve of this, and he proposed to deny the request. He made the motion, and the motion carried unanimously. That's all that I would provide. Thank you.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant must first overcome a res judicata issue. To overcome that issue, appellant must show substantially changed circumstances, substantial new relevant evidence that was not available at the hearing on the prior appeal, or that the application of res judicata would create manifest injustice. If that issue is overcome, appellant is requesting a use variance and an area variance from the minimum distance requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
All right, thank you for that. So to Raymond and to Jocelyn, our applicants here, we first want to address the issue of what's called res judicata. As you heard, and as you know, there is a previous variance that is pretty similar, if not the same, as the request that you're making here today. And because that variance has already been decided by this board in the past, we are kind of limited in terms of being able to decide your variance. So our first question today is, do you have any evidence that, there's something that is substantially changed? There are some circumstances that are new that didn't exist at the time the variance was heard in 1996 that you would like to present to the board today?
Yes.
All right, go right ahead.
Okay, good morning, board. Good morning, Madam Chair. So back in 1996, they did have a driveway. However, now after 29, almost 30 years, we have a rear parking. So the variance was denied because of the traffic flow. So we did come up with a plan, and I would like to go over my traffic and parking plan with you guys, if that's okay.
Okay, go right ahead.
Okay, so all families will enter my main driveway and pull all the way up to the back where there's a rear parking area for drop off and pickup. We'll have staggered times so cars don't overlap. Once one car exits, the next car can pull in, keeping things smooth, avoiding any backup on West 48th. The driveway is wide enough for vehicles to safely enter and exit without blocking traffic or driveways. The rear parking area allows cars to turn around easily before heading back out to the street. I will have myself and staff assist during busy times to help direct traffic and make sure everything runs safely and efficiently. My neighbor, who is a certified traffic control specialist, who is the Warris family, they also sent us a recommendation letter. He is a traffic control specialist and he's offered to train myself and anybody else who might get hired in the future on proper traffic safety procedures. This plan keeps cars off the street, it prevents congestion, and it ensures a safe environment for families and neighbors alike. The long driveway can accommodate multiple cars. The wide rear area can serve as a turnaround and a parking zone, and everything is contained safely on the property.
Okay, so is this the same driveway that existed in 1996?
Yes, there's a driveway. Now the driveway is paved and we have half of the backyard is also paved where the cars can go down and turn around. And as you can see the pictures here. Now, this is for an example, Madam Chair. That is a food buggy that's in the backyard. And that is about 1,500 pounds. That's the size of a small car. So we left that there so you guys can have a visual to see how big that property, that rear parking it can be or is.
Okay, any questions from the board on the race judicata issue?
Madam Chair, one question for the appellant regarding this this plan. So the driveway was there in 1996. The only change and people dropping off and picking up still have to go into the driveway through the front, correct? They have to drive around the house. There's not an alley in the back, right?
No, right. There's another picture that shows the driveway that I sent. It might have been before that where you can see the long driveway. That one. So oh, it was the picture in front before this one. So that's the driveway. So that driveway back in 96, they did have a driveway where you can pull in the cars, but it was not this long and it was not connected to the backyard, how we connected it. So that's the biggest change that we've had.
Okay, thank you for clarifying that.
Yes.
Any other questions from the board regarding race judicata?
And with respect to the daycare, are there any other changes that are being made that are different than the 1996 case?
Well, to my knowledge, when we were waiting on the transcripts and stuff, the main concern was the traffic, and that's really why they gave the variance was the traffic. They didn't want to hold up the traffic. So that's what I've been presenting, but everything else in the daycare, how the daycare would be, the house is still the same. The what's different is the driveway, the rear parking, and then our traffic plan that we have going forward.
Okay, so in the first case, the application was related for 8 children. How many children do you anticipate having in your application today?
So I understand that from the state of Ohio, there's 2 different daycares, and I understand that the board is a center regardless of how many children. The daycare that I would like to have is up to 12 kids with 2 people working. So it would be 1 person per 6 kids. So it can be up to 12 kids. And that can be after school, before school, it can be, so it's all going to be staggered times. It could be infants, toddlers, preschoolers. It just depends. Currently now, I don't have anybody, but I have my baby who's going to be 1 years old. And this is pretty much why we want to continue doing like an in-home daycare. so I can be home with my baby and also help the community.
All right, so I will now turn to the board. We can have a vote on the res judicata issue. If you feel that there is substantial change to meet the standard, you can vote yes. If you feel there is not substantial change to meet the standard, you can vote no. We'll have Madam Secretary call the vote.
And you want, am I waiting for a motion or no? I'm just going to, it's going to be yay or nay?
I mean, unless somebody wants to make a motion on the res judicata, I feel like maybe just a vote is fine.
Okay.
So we're voting to uphold the res judicata or deny the res judicata?
Yeah, we're voting that res judicata would apply or not apply.
Okay, so in the matter of whether res judicata applies or not, how do you vote, Ms. Bates?
Yes.
Res judicata does apply?
Yes.
Ms. Holzer?
I want to make sure that I'm understanding correctly. If we vote that res judicata does apply, we are saying that there is insufficient evidence and that therefore we would not be able to move forward with the case.
Correct.
So then I would say no.
Okay. Mr. Madison?
Yes.
Ms. Roca?
Yes.
Ms. Wilson?
No.
So let me get the vote again. So are we determining, so we're determining now, were there 3 yeses? Is that right?
I think there were 3 yeses that said res judicata does apply, and then there were 2 nos that said res judicata does not apply.
Okay, so and then so that means that there's not significant change for us to hear the
Even
new
hear the case.
information.
Correct.
So that means that this variances could not go any further and that we would
That
be
res
denying.
judicata would apply, yes. And just to confirm with board members that nobody voted mistakenly. Okay. All right. The vote is in.
So that means, Madam Chair, that this variance has been denied. We did not find enough reason to rehear it. The decision from 1996 remains, and this variance is denied based on res judicata. The board will ratify this decision next Monday, and we will send the appellants a letter.
All right, that concludes this matter. That concludes all of our matters for today. We're now going to move on to old business. I do have on our old business numbers 2 through 5 and number 8 that is up for ratification. Any objection?
No objection.
No objection.
No objection to number 8. It's not present on the other.
No objection.
All right, so all of those will be affirmed or ratified without objection. And that concludes our old business. It is now 11:15 and we are adjourned. Have a good day, everyone.
Thank you.
Thanks.